You are watching Morning Musings with Reinhard von Hennigs, chairman and founder of Bridge House Law in Charlotte, North Carolina.
What is bourbon? Hello, this is Reinhard von Hennigs. A few musings ago, I talked about the champagne of beer and the issue that this American brewery was not allowed to bring US beer branded as the champagne of beers to Europe. Why? Because a local region prohibited this. So let's talk about bourbon for a moment. Bourbon is a type of American whiskey which is distilled from a mash made primarily out of corn. As we may know, the corn mash needs to contain at least 51% of corn. It must be aged in new charred oak barrels. Other requirements are for the bourbon that it has been produced in the United States and was bottled with a minimum 80% proof. Trade protection, which attaches to the name bourbon, is provided by a number of different legal regulations. Inside of the United States, bourbon is protected as a distinctive product. The United States protect bourbon under federal law. This means any whiskey labeled as bourbon must meet the minimum standard of bourbon in the United States, which includes mash composition, aging in new oak charred barrels. So when I talked about the champagne musing, so to say, the question of regional differentiation came up. In addition to the federal regulation, certain states may have some local laws which give own rights. So, for example, Kentucky, which is known for its bourbon, has an established rule that the bourbon trail only can include a certain number of brew, which includes distilleries where they use the product. Bourbon is sold in many countries all over the world, but the regulation about what bourbon is differs from country to country. The legal concept known as trade protection comes along the line of the name of bourbon. They include trademark laws, which is a brand protection or logo protection, as well as a geographic indication. All of this is there to protect the reputation of the brand. So what is the real origin of making sure that bourbon is limited to US-made bourbon? Many free trade agreements have something to say about bourbon. The US has different free trade agreements, and generally they limit the word bourbon for anything which is used outside of the United States when it is not made in consistence with the US bourbon definition. Let's talk about the United States-Mexico-Canada Agreement, USMCA, formerly also known as NAFTA, or sometimes NAFTA 2.0. This whole new USMCA replaced the NAFTA treaty, but it is still very specific on the definitions of the word bourbon. It is a geographical protected indication. Looking into the USMCA, you will see that American bourbon producers are protected against unfair competition from within Canada and Mexico. It also means that bourbon producers can prevent any unauthorized use of bourbon, meaning if they don't fit and fulfill all the requirements of bourbon, they cannot be called bourbon. So let's talk about the European Union. In the European Union, bourbon is registered as a protective, distinctive product mark of the United States, and the name is secured under European Union law. The geographical indication, which is a protection system to provide legal protection for food and drinks, define that only those products which originate from a specific geographic region and possess certain qualities of that region can be called after that place of origin. So with bourbon, bourbon does not seem to indicate any city, state, or region. But bourbon whiskey is protected as a GI in the European Union, which means only those products which can be used in the European Union when they fulfill the strict requirements of bourbon. Only those can be labeled bourbon. And as I said earlier, it needs to be a 51% corn and aged in new charred oak barrels. Different European trade agreements, known as free trade agreements, FTAs, govern this. So the European protection level is not a real FTA definition by itself, but it is part of the FTA. So let's talk about where the bourbon is prohibited in Europe. And let's look about, are there any cases where bourbon was not allowed to be used? And the quick answer is yes, there have been different cases where the word bourbon was not allowed to be used. Let's talk about the year 2018. The Swiss company known as Umwelt was sued by the Kentucky Distillers Association, KDA, over its use of the word bourbon on their Swiss-made whiskey. The association in America argued that the use of the word bourbon for a non-US product is misleading, and therefore it violates the European Union protection system. The case was eventually heard by the Swiss federal court system, which ruled in favor of the KDA. So the conclusion is the term bourbon cannot be used for a Swiss-made whiskey. As a result, Humble was required in order to remove the word bourbon from their whiskey, from its marketing materials and from the labels. This case clearly demonstrates that the geographic origination of any whiskey is limited, and therefore the word bourbon whiskey needs to be according to US laws. So are there other regions available where there is a certain trade protection? And there are a couple of other areas, again, along the line of whiskey. Let's talk about these. First of all, there is a Tennessee whiskey. Tennessee whiskey is a type of whiskey which is produced, you may guess it, in the state of Tennessee. So the filtering of the whiskey through a sugar, maple, charcoal before aging is required. Only then can it be called a Tennessee whiskey. Number two, there is a so-called straight rye whiskey, which is a type of whiskey which is made from mash of at least 51% rye, and again, aged in charred and new oak barrels. So the term straight rye whiskey is again protected under the European Union law as a geographical indication. Number three, there is a straight bourbon whiskey. This whiskey is a type of bourbon which has been aged in a barrel for at least 2 years and has not been blended with other spirits. So the term straight bourbon whiskey is protected under European Union law again. And lastly, number four, there is a corn whiskey. Corn whiskey is made from a mash of at least 80% of corn, and again, aged, and this time in uncharred oak barrels. So the name corn whiskey is protected again. These clear American definitions are very similar to the European Union understanding that the word champagne is limited. So if you are a company trying to import things from outside of the European Union and you want to call it anything which is confusing to US whiskey, check before you import. As I said in my champagne musing, the rights are necessary to be checked prior to entering the market. Don't use any geography in your brand when you do not originate your products within such geography.
Whether you're a private citizen, an international business leader, or simply someone eager to stay on top of the latest news, this book is a great way to get caught up on the most recent developments in the worlds of international business, tax, politics, and social affairs. Go to morningmusings.com and order your copy today.
Thank you for joining us today. If you would like more information about British House Law, please visit our website at bridgehouse.law. Before you go, make sure to like this video and subscribe to the channel for more up-to-date content. Bridge House Law, business-minded, client-focused.